The Fifth Amendment is very complicated because the amendment deals with life, liberty, and due process of law. That's the key. What is due process? It's so hard to explain, but what is it? What is due process?
Police and courts follow the procedures that guarantee your legal rights, constitutional rights.
Yes.
Not everything according to the law.
And sometimes due process is decided differently by different states, different judges, different opportunities, whatever.
And add it, take it away, Miranda, I mean, that became due process.
Yes, and we're going to discuss Miranda and Brown versus Board of Education for the Fifth Amendment cases. Now, the other thing in the Fifth Amendment, no person shall be held to answer for an infamous crime unless indicted by a grand jury. Now, this was quite a coup that the framers made. What is a grand jury?
Here's evidence that's presented to it by the prosecutor or the attorney in order to believe that there is enough evidence to
bring the person to trial. Like if somebody accuses...
It's a secret group of chosen citizens.
Right.
The prosecutor's case before indicting.
Yes, and let's suppose a woman accuses a man of rape. They have to determine whether or not the case is valid, whether the woman is trying to trick him or the guy actually did it. But if there's an inkling that the case is legitimate, they will remand it over for trial. So that's a grand jury, and that's a terrific right that we have. And the grand jury will take away a lot of cases that are bogus. So it won't crowd the court's calendar. And how do they pick a grand jury? When you call for jury duty, you could be called what, for grand jury or regular jury?
I think so.
Now, we have two types of juries in this country. Petite jury with 6 people, and you have a 12 jury people. You can also request no jury at all, where the judge makes the final decision. What's the pros and what's the cons?
Judge?
People believe that if you're guilty, you want a jury because you could use your lawyer's talents to sway the jury.
Absolutely.
If you're not guilty, if you're innocent, people usually believe it's better to have the judge because the judge will hear the case fairly, won't be swayed by any other attorney, and you'll probably get off because he knows enough to get
Exactly, because he knows the law. Now let's suppose, just for argument's sake, that it's a hate crime case. And it's a case where a white man killed an Arab because he was afraid he was a terrorist. And it becomes very sensationalized in the news. And the lawyer sometimes says, my client can't get a fair trial. So what do? They ask for a change of venue. And sometimes, not often, a change of venue is given. And what they do is, take for instance the Rodney King case. There wasn't a change of venue, but it was a case that the whole country was up in arms in. And 50% believed one thing and 50% believed another thing. It was all over the news, the radio, the television, and you can't get a fair trial. It's impossible. So sometimes the judge will issue a change of venue. Not often, but sometimes, if he feels that the accused is at a disadvantage. And of course, the lawyer of the other side will vociferously say no change of venue. He can get a fair trial because we can pick an impartial jury. Now, you're a lawyer. When you pick a jury, and juries are being picked, what do the lawyers look for?
You mean prosecution or the defense?
First, let's go with the prosecution. Let's take, for instance, a case where a guy had 20 kilos of heroin, and he has to be represented. and the prosecution has a pretty solid case. So what does the defense want on the jury?
Defense?
Yeah, what does the defense want on the jury? He's under the gun. He's going to lose. But you can't predict what a jury will do. Like, look at O.J. I mean, that... When I was teaching, and this was, what, 94, when O.J.'s case came on, he was as guilty as... You didn't have to be a genius to figure out with all the things that he did. And there was a guy with a real personality disorder, because before that, he was a great football player, handsome, affable, he acted, he did commercials, he was very popular, and then all of a sudden he turns into this monster. Now, the evidence, the preponderance of evidence, and especially when he ran away and he had that big car chase, and he had all these people living in the house, and it was pretty apparent to everybody that O.J. was guilty. And of course, the problem was the prosecution and the judge were weak, and it was on television. So that made it in favor of O.J. because people watched it like they would watch a soap opera. And when O.J. tried on the glove, it didn't fit, so it quit. So when a jury hears something like that, it sticks in their mind. But a jury, the defense wants people, say, who are African American, who are like football. What else? They don't want women on the jury. Okay, they don't. What's that?
Or being beaten.
Or being beaten. And they'll try to get somebody who's sympathetic towards O.J. On the other side of the coin, what does the prosecution look for?
Women. The prosecution just wants someone who's not an outlier. They just want someone down the middle who hasn't had any bad experiences, has no preconceived notions about police or the state. Or
right, and the lawyer will often say, did you have a relative that was killed? Do you believe that you can give an impartial vote? And lawyers have something called preemptory challenges. They have 6, I believe, in most cases. And you don't have to give a reason. If you don't like the juror, you could say, I don't want him or her. And this preemptory challenge is given to both the prosecution and the defense. And the preemptory challenge is, you don't have to give a reason. If you might just not like his looks, or you might think that he's a fraud, or you look at him and you see that he's not paying attention, whatever. You know, you want to get the edge when you're in trial, when you're, defending somebody. And the jury, again, sometimes takes days or weeks to pick. Sometimes the jury is impaneled. What does that mean? If it's such a case that is all over the papers, they impanel the jury where they lock them up in a hotel. They sequester them. And they lock them up in a hotel, no newspapers, no television, and they meet every day, and they go over the case, and sometimes 2 people dissent, 3 people dissent, and the others want to get out of there. They want to change their mind and either get the guy guilty or innocent. And sometimes, if you have to watch, and a good lawyer is very adept at that, can a juror be bribed?
You mean legally?
No, illegally. It's illegal to bribe a juror. But sometimes it can happen. I mean, it's silly. I was watching Law and Order, Criminal, SVU, whatever, and there were 3 very, very rich boys that killed another boy and raped a girl. And they thought all their money could buy them off. And for the 90% of the case, there was a very, very young court officer who had access to the judge's chambers. So they bought the girl a Mercedes, and they gave her $50,000 in cash. And one of the kids became her lover. He was very rich, handsome. And she allowed him into the office and they bugged the judge's office. So they had a foot up. So they were acquitted at first. But then the SVU said, this isn't right. The guy killed the witness that we were going to put on the stand. And eventually they figured out that it had to come from the judge's chambers. So they went up to the judge, and the judge was angry. She said, this is ex parte. You shouldn't talk to me outside the case. So they got the judge outside, and she put a jacket on. It was very cold. And the district attorney said, we think your house is bugged. And sure enough, they got a guy in, and there was 2 bugs, and they found it. And the girl, they said, you're going to jail for 30 years or 50. They said, your parole officer hasn't even been born yet by the time you get out of jail. So she got scared, and she was taken in by these guys, and they were rich, and she was a kid, not 21 maybe. And she spilled the beans, and of course they caught the guy, and he was guilty. But you have to watch out for things like that when you're an attorney.
That's the one thing that got Jimmy Hoffa on, jury tampering.
Yeah, how did he do it?
I'm not sure, I don't remember the details. But
When Jimmy Hoffa
he was accused of,
taking pension,
stealing from a pension fund, and he was acquitted, and then later they found, he was found guilty of jury tampering, but I don't remember the details.
and Bobby Kennedy wanted to get him bad. When he was picked as Attorney General, his father insisted that John Kennedy choose him, and he knew Bobby was very bright. Now that's real nepotism. But he was okayed because he really had qualifications. And I think he would have been a better president than his brother. I think he was sharper, and I think he was tougher than John Kennedy was. But we'd never know because Sirhan shot him, and he was dead in San Francisco in 1968. So we would never know. But going back to the Fifth Amendment, no person shall be tried for the same crime twice, and that's double jeopardy. Now let's discuss this. GPORADY. What's double jeopardy? Why did they put that in the Constitution? There's a reason. There's a reason.
The government, England, the king, whoever couldn't constantly harassing or people repeatedly charging him with the same thing.
And it's crazy to charge somebody. If you pay your dues and you go to jail, they can't charge you again for the same crime unless you commit the same crime and add other things to it, like murder somebody or rob or rape or whatever. It's a different crime if something is not the same. So you can be tried for another crime, even though it might resemble the first crime. But
if you're acquitted, you can't be tried for the same thing.
Yeah, if you're acquitted, you can't be tried. And again, on TV, I saw one of the law shows, and a little boy was lured into a basement, and like a 10-year-old boy who was a sociopath took rocks, stuck it in his mouth, and the kid died. And the kid who died, his father was a psychiatrist. So he felt sorry for the kid because the kid had a hard life, but the kid was very glib. He was very smart, and he would say, "Oh, Mr. So-and-so, I'm so sorry for what happened to Henry. He was my friend."
That was on Law and Order.
Yeah, it was Law and Order. And what happened was he wanted the kid to go to some kind of tough love outfit. So the mother didn't realize he was a sociopath. She stuck up for him. So she figured he had problems, and they would tough love him and solve it. But when they got up there, the kid said the kid was crazy. He would burn cigarette holes on other people. He would try to drown you. He would put a dead rat in your bed. So the prosecution realized that the kid was guilty. So the father felt so sorry for the kid at first, he wanted him tried as a juvenile. So when you're tried as a juvenile, the most you get is what, 18 months?
Until you're 21.
Or until you're 21?
It's severe, be it 21.
Okay, but usually it's not as bad as being in an adult prison. So the psychiatrist got so angry at the kid, he went into the hall, grabbed the cop's gun, and shot the kid. So they arrested him for second-degree murder. And he claimed that he was overwrought, and his defense was that he wasn't in his right mind, almost an insanity plea. And when they questioned him, he wrote an article 15 years before saying that a child should not be executed. They should be put away in jail. And it was a pretty liberal view about the article that he wrote. But then he shoots this kid, and they ask him, "But you wrote that?" He said, "But that was 15 years ago, and times change." Hence, he was a psychiatrist, and he was clever, and he beat the rap. So at the very end of the show, Olivia and Elliot asked him, "When did you decide to kill the kid?" He said, "In the courtroom. Once I knew what a monster he was, I planned it out in my mind." Because they said, "You can't be tried for the same crime twice. So just tell us." And he said, "I knew the cop was going to be there. I took his gun and shot the kid."
Right. He also said, "I won't kill again," but
Right.
the boy would have.
He said, "The difference is the kid will kill again. I won't." Telling them I'm not a sociopath. So if we look at the Fifth Amendment, there's two cases that are landmark cases. You want to read them? Mm-hmm. They're on 2 pages, and they basically repeat themselves. So first do Miranda versus Arizona. We'll talk about it, then Brown versus Board of Education.
Can we read this side?
Read this one,
You don't need,
Miranda, and
just,
this one and this one.
which Miranda do you want?
First read this one and then read that one. They're pretty much the same.
No, they're the same case, is what I'm saying. You got 2 Mirandas.
Yeah, but they're different yet the same. Just read both. Read that one first.
All right, Miranda versus Arizona. It's under the topic self-incrimination and due process, so Fifth Amendment. Ernesto Miranda was arrested after a crime victim identified him, but police officers questioning him did not inform him of his Fifth Amendment right against self-incrimination or his Sixth Amendment right to the assistance of an attorney. While he confessed to the crime, his attorney later argued
Read it again.
that his, it says read more, go on.
Okay, read Miranda again.
Read the same thing
Yeah,
again?
read the same thing again.
Ernesto Miranda was arrested after a crime victim identified him, but police officers questioning him did not inform him of his Fifth Amendment right against self-incrimination or his Sixth Amendment right to the assistance of an attorney. While he confessed to the crime, his attorney later argued that his... Go on. What do you...
That is what? Where are we?
Probably that his sentence, his conviction.
That his conviction was overturned.
That his conviction was incorrect or something like that. This is the end. This is
Right.
the decision. Okay, hold on.
What did the decision say?
Okay, you want the decision?
Yeah, read the decision. Miranda was guilty. Okay, he was guilty. No question.
The prosecution may not use statements, whether exculpatory or inculpatory, stemming from custodial interrogation of the defendant, unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination.
So basically, what does it say? Miranda got off why?
He got off because they didn't follow the procedural safeguards of the Fifth Amendment and Sixth Amendment of the Constitution.
Right, he did. They didn't tell him you have the right to remain silent. You're entitled to an attorney, and therefore he got off. And that was a technicality, and that happens when people are sloppy, and if they're not properly trained, and whether it's a jurist or a policeman or a prosecutor, it doesn't matter. You have to follow proper procedure. If not, the person gets off.
They've had a number of cases at dealing, at what point do the police have to respond to that?
I'm sorry?
Meaning the question would be what determines custodial interrogation, what defines custodial interrogation?
At what point, exactly, at what point do the police have to respond to that?
Well, they have to say, you have the right to an attorney. If you can't afford one, the state will...
The question would be if they stopped you and said, can we talk to you? Is that custodial interrogation? Well, were you really in custody, or is it just they asked you to stop and you complied without them forcing you?
And he admitted to his crime.
But if they said, hey, stand there, and forced you to stay or held you, then that's custodial would be sort of the determination. But if they passed you on the street and asked you a question, they would say, you could have walked away, even though most people would be inhibited against walking away from the policeman asking them a question.
But you can. You have that right.
Right, but that's what they determined. Now, the last part, what we should have read was that his attorney argued that his confession should have been excluded from trial, which is what the Supreme Court agreed to. That was
Okay.
the sentence. It was
So basically, Miranda was guilty, but he got off on a technicality. And the technicality was he wasn't given his constitutional rights. And there was another case.
You want me to do Brown?
Yeah. Before you do Brown, I told you in the 1890s, Plessy versus Ferguson, separate but equal. 50 years later or 60 years later, what happens?
Okay, all right, without giving away the decision. In Topeka, Kansas in the 1950s, schools were segregated by race. Each day, Linda Brown and her sister had to walk through a dangerous railroad switchyard to get to the bus stop for the ride to the all-black elementary school. There was a school closer to the Browns' house, but it was only for white students. Linda Brown and her family believed that the segregated school system violated the 14th Amendment and took their case to court. Federal District Court decided that segregation in public education was harmful to black children, but because all black schools and all white schools had similar buildings, transportation, curricula, and teachers, the segregation was legal. The Browns appealed their case to the Supreme Court, stating that even if the facilities were similar, segregated schools could never be equal to one another.
And the reason was that a black child would get an inferior education to a white child. So therefore, Brown versus Board of Education was a landmark case where segregation ended in theory and integration came about. But you had Jim Crow laws, and there were a lot of ways to harass black children. They could ignore them, they could threaten them, and it was very tough for a black child to go to an integrated school. And even in 1963, where you had James Meredith going to the University of Mississippi, the same thing happened. And you were in the heat of the civil rights movement at that point. And it all started, they say with Rosa Parks, but I believe it started with Jackie Robinson, because he was my contention is
player in
that
Major League Baseball.
in Major League Baseball, the owner of the Brooklyn Dodgers, his name was Walter O'Malley, and the general manager was named Branch Rickey. And he said it's time to integrate the leagues. But there were some selfish reasons. The Negro leagues, which played on a separate circuit, they were loaded with talent. You had Jackie Robinson, Willie Mays, Hank Aaron, Frank Robinson, great players that eventually made it into the Hall of Fame and became managers and players in Major League Baseball. And they were denied the right to play baseball. When Jackie Robinson went to the Dodgers, there was a petition that they didn't want him on the team, and they ignored him. But Pee Wee Reese, who was the captain of the Dodgers, he was a shortstop, went and put his arm around Jackie, and he said, Jackie is part of this team. And if you don't like it, you have to deal with me. And he was very well respected. But Branch Rickey told him, you have to take the abuse for 2 years. They threw black cats on the field, watermelons, anything derogatory towards the African American. And Jackie Robinson took it. But in the third year, he said, you can fight back now. So when he would when he would play second base, the other players would try to spike him. They had metal spikes in those days. They would try to cut his legs, and they would throw at his head. But he was such a great ball player that through merit, he got his respect. And then right after Jackie came Roy Campanella, who was the catcher, and Don Newcomb, who was the pitcher. And then guess what the last team was to integrate?
Tigers.
No.
Tigers were one of the last. They didn't do it until 58 or 59.
Well, the Boston Red Sox, 1959. And the player was Pumpsie Green. And Pumpsie Green he was a great jumper. And he played the outfield, and he could reach over the wall, not the wall, but because in Fenway they had that big wall. He could reach up and, grab the ball. But and Elston Howard, the Yankees, was before him. I think in 56 or 57. And he was the first black player on the New York Yankees.
Larry Doby was the first.
They're the Cleveland Indians.
Larry
Larry Doby was the first of the American League.
48.
And he never got the credit that he deserved.
He just recently got elected to the Hall of Fame.
Yeah, and he died recently,
3-4
too.
years ago.
Didn't he die within the last 5 years?
The Tigers, when I came here in 2009, Tigers had only one African-American player.
Really?
So they had one.
And what happened?
They get many.
But I remember Gates Brown.
No, he's saying it on the 2019.
Oh, in
2019.
2019.
But half the team are Latino players from Venezuela.
They had-
Yeah.
Cuba.
Now you have black players going into basketball and football because you can make more money quicker, and you have Latino players playing baseball. So the races have switched to different sports. Originally, African Americans went to boxing. That was the first sport that they went to. And the reason was that there was no barrier, there was no racial barrier. If you were good, like Joe Louis, he was a hero in the 1930s. And whites and blacks loved him, but like they say, he knew his place. And he didn't cause any trouble. And here's a guy who went into the Army, fought all these exhibition fights, and then the government hit him with $200,000 in back taxes. And he was broke because he didn't know how to manage his money. He was married 4 times. He paid all his alimony. And at the very end of his life, he went into professional wrestling, which was so demeaning to a guy of his stature. And at the very, very end, he became a greeter in Las Vegas. Frank Sinatra and the Rat Pack got him a job to play golf with celebrities because he loved golf.
Joe did some things, and he was in the Army, because of some connections he had made that were some kind of subtle changes about how black soldiers were treated before they were completely integrated.
By Truman.
Yeah, things I don't remember, wish I could remember the details, but these were even before that, but then Truman integrated the Armed Forces.
It was interesting that Max Schmeling, who he fought twice,
Right.
paid for Lewis's funeral.
Not only that, when he lost to Max Schmeling, Roosevelt came to visit him at the camp when he had the rematch. And Schmeling lost his title, and Lewis was the champ, even though he lost to Schmeling when he wasn't the champ. And he was so angry and so humiliated that he trained and trained and trained. And they fought in Yankee Stadium. What were 38, 37?
37, 38, I think it's 38.
And Joe Louis pummeled Max Schmeling, knocked him out in the first round. And if you listen to the commentator, he had this big raspy voice, and Schmeling is down, and Schmeling is down. And Schmeling and Lewis became wonderful friends. Schmeling never believed in the Nazi Party. He never joined the Nazi Party. And he knew he was not in the school of Hitler. Him and Joe Louis became very close friends, and Max Schmeling was very rich. And he basically supported Joe Louis in his time of need. So even with all these constitutional amendments, you have things that go out, not amendments, but you have the races coming together based on athletics or based on scholarship. So it's very, very interesting. Now, this is the biggest landmark case, Brown versus, you read that, right?
Right, and then you want the decision?
Read the decision.
The court decided that state laws requiring separate but equal schools violated the Equal Protection Clause of the 14th Amendment. Their ruling included, we conclude that the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal.
Okay, so schools were integrated in 1954. But even though they were integrated, blacks still had a very, very hard time because the white kids harassed them, didn't talk to them, tried to trip them up any way they can, and they were very cruel to the African American student. And it wasn't until the 60s, maybe the 70s, that, that black students got a fair shake. Now, my favorite case on the Fifth Amendment, when you're granted, no, this is, let's see, maybe it's the Sixth Amendment. Okay, Amendment number 5 also, no self-incrimination. You cannot be a witness against yourself. Why?
Can't be compelled to be a witness against.
Yeah, you could lose the case, basically. And also, you cannot be deprived of life, liberty, or property without due process of law. So you get this due process business.
I saw something the other night that was really bothered me. There's some states that have what we call forfeiture laws or civil seizure. In Texas, it's probably the worst. If they have a legal reason to search your car and they find a lot of money, like a few $100s or something, they can claim that that's
Stealing?
well, no, that it's suspicious and it's beyond what it seems to be necessary for your purposes. It's some outlandish.
I remember last night I was watching Goodfellas, and Henry Hill robbed the airport with $400,000 of untraceable cash because the soldiers transferred their francs into dollars, and they had a plan where they walked out with $400,000, but he paid tribute to Paulie, the boss. And he said to him, that's a lot of money for a kid like you. If anybody asks, tell him you wanted playing craps in Vegas. That's what he told him to say. But Amendment 5 also says the government cannot take property without giving you just compensation. And that's called eminent domain. If they have to build a highway through your property, and it's essential, I mean, nothing can be done. The government does have a right to take your property, but they got to give you top dollar. And they got to relocate you where you want to go. They just can't take your house and take your property away without compensating you, and they usually compensate you double or triple what it's worth.
I've never heard that.
I thought it was just fair market value.
No. It says fair market value, but the government, look, who would want to leave their house? Let's say a person lives 25 years in a house.
Yeah, but I think they're just doing it to avoid a court case. Rather than argue about the price, I think they'll give you more than.
Of course, you know.
I've always heard that if you had a choice, and we went through this where I lived, they talked about putting an entrance ramp onto 696, and it would have gone right through our neighborhood. We were praying that, you know, if anybody's going to buy it up, let it be a private company, not the government. Because we were told the government will not give you a dime more than they have to,
Well,
fair market value, but a private company will try to entice you.
well, yes,
to leave.
especially in a co-op or a condo. Let's suppose it's rent controlled and it's in New York City, and they have to build some building or they have to build a highway, and it's imperative that it has to be built in that place. They always will offer you double, triple, or quadruple the value because people won't leave. And some people who are really set in their ways will make them literally pry them out of their house and put them somewhere that's at least equal or probably better. Like you said, they want to avoid a loss. They want to avoid trouble.
That sounds more like something private developers would do.
But the government has the right to take your property away if it's necessary. And it's only if it's, I mean, if they want to build a highway and they could go around you, but it costs them more money. Tough. They can't take your house away. They can only take it away if it's the only option left. And that's called eminent domain. Now,
There was a case though where they expanded it.
what do you mean?
There was a case,
Connecticut.
Kello or something in.
Kilo versus New London.
New London, Connecticut, where the government forced someone to sell their land so that a private developer could put up a project. And the court ruled that that was okay because if it was economically beneficial to the community, the government could force you to sell your land so that a private developer could put up a project.
Now, I bet you if that went to the Supreme Court, that would be an
No, that's
interesting...
what I said.
Supreme Court
The Supreme
upheld
Court okayed it, and that's where everybody screamed at the Supreme Court. This was like 5-10 years ago.
And in other words, you're telling me, let me get this straight, that the government can order you to sell your property so a private developer can benefit.
Yeah.
Yes, they exited. It was a
Exactly what
very
they said.
controversial case, but it was fair.
It's called Kilo versus New London.
Yeah.
Well, I have here,
KELO versus New London.
oh no, I have a different one.
And aren't you do it for Detroit?
What's that?
And aren't you do it Greystone or Gray something?
Well, in some studies, some states have economic development corporations or committee, but it's a state
Right.
entity, and they can go in and say they're gonna redevelop an area.
Well, they did that in White Plains, and people were screaming. In other words, White Plains was lily white, smattering of African Americans and Latino Americans and Asian Americans. And in 1964, urban renewal came about. So they took apartment buildings and built them, and they were called the projects. And African American families moved in at a reasonable rate, and they were nice apartments. But unfortunately, there were a lot of criminal element, and there was a lot of drugs, and they wrecked the building, and there was all kinds of court cases in White Plains regarding is this constitutional or unconstitutional. But in the end, it was constitutional. Urban renewal was part of the Johnson's Great Society. So it was okay. And I'm sure many cities did that.